abortion protesters outside of an abortion clinic could not come within 35 feet. So you have the issue of people seeking to exercise their constitutional right under the Supreme Court's decision to have an abortion, and people exercising their constitutional right under the First Amendment to tell people and harangue people, harass people, or to provide information, whatever it might be, the abortion protesters. It's interesting because the buffer zone around the Supreme Court itself is larger than 35 feet. But if you've ever tried to protest, those of you in this Aspen group, I know they're there often.
Yes.
But what the court was struggling with, and why the liberal justices went along with the majority there in that case, is that it was a relatively fact-specific decision. The court was deciding that 35 feet is too far, that people can, and they had decided just a year or two ago, the protesters, this Baptist church in the Midwest someplace, that wanted to protest at military funerals and holler out nasty, nasty things to the poor bereaved family who's trying to put a soldier to rest. And the Supreme Court upheld the right of the protesters to make noise and to protest on a fact-specific decision given based upon how far away they were, how much noise they were, could they be heard, and that sort of thing. So the liberals justices went along, I think, with this decision, saying that the Massachusetts limitation was too broad, that people were entitled to be closer to that. It's going to throw it back to the legislature. It angered the 4 conservative members of the court who, very strong, I think it was 4, the conservative members of the court saying, you're putting speech in different categories. Justice Scalia, I said before, he write in his concurring opinions, this is one where it's a very strong, he said, we're writing in the majority here an abridged edition of the First Amendment applicable to speech against abortion. And then he calls it on a subsequent page, abortion speech only jurisprudence. The point that they were making is that you're making content decisions with respect to the nature of speech. If it was speech about some other subject, you wouldn't have the idea of these buffer zones at all. But because abortion is perceived in a certain way, protesting abortion is going to be perceived more harshly, and limits are going to be, even limits such as the one they were talking about here, it's going to be more severe restrictions permitted by people in the abortion context than in other contexts. And so there was a content restriction, and the dissent, or the concurrence, was very strongly on that basis.
Do you want to weigh in with the
judges? Yeah, I do. So this was a case where you had to really carefully parse what the court purported to be looking at and the record. And since I'm a believer in the record, you have to accept the record that you get. And in fact, this case wasn't about abortion protesters, right? So what the individuals said, or what the group said in this particular case, was that they weren't abortion protesters, that in fact they were counselors, right? That what they wanted to do within this 35-foot zone was quite different than holding up placards and signs. That essentially what they would say was, can I walk with you? Do you want me to counsel you? And some people would have the rosary or whatever they claimed. And this was apparently unrefuted, that this is what this particular group was engaged in. And I think the 4 justices were very much aware that many other states, New York and others, have pretty powerful laws about buffer zones for protesters and have actually criminal penalties that attach to harassing, following, intimidating, obstructing anyone from entering an abortion clinic. And I think what the court thought was that those kinds of means are sufficient to hold back the people who would be the kinds of more aggressive protesters. And so they were willing to go along with this 35-foot, may I walk with you. Now, I think many of us are not satisfied with that because, frankly, this is a very personal decision. It's personal space, it's personal time, and frankly, 35 feet. Electioneering, you go to the polls, it's 100 feet. You can't hand out leaflets before you go into a polling place. I don't think anybody thinks that 35 feet is an incredible amount of space. So it's a bit of a strange decision, but I read it very carefully, and I think that the 4 more, I wouldn't call them liberal, but more centrist justices thought that they were engaged, as Ted said, in a very specific fact situation.
But some of the speech, and there was a record, was broader than what the court was actually dealing with. There's some of it wasn't, may I walk with you? Some of it was, this is, you're killing a life. And the slippery slope there is if you start making decisions based upon this This is counseling as opposed to protesting. Is it nice speech? Is it benign speech? Is it polite speech? Is it robust speech? That is really tricky.
No question. And you remember that Justice Scalia's concurrence, what he was so angry about, was that he believes that any buffer is attacking a speech based on its content, that he believes that this is about people, as you say, who are opposed to abortion. And the court refused to accept the idea that this was some kind of attack on the content of the speech. And that's what he was mostly angry about. He wanted the buffer zones branded as being efforts to get, at those who are against abortion. And so I think the decision is deeply, deeply troubling in many ways. I'm not exactly sure what the 4 justices were up to, but I think they are hoping, and frankly, one of the reasons I worry is because I've seen these justices do that in other cases where they hope, as in the Northwest Austin case before the Shelby case and so forth, that if they walk this narrow path, they may be able to circumvent greater damage, and I'm not sure it's true.